The last two sessions have shown that I don't need to introduce this at all. The importance of the independence of the judiciary is obvious. What I do want to say is we have a wonderful panel. I'll introduce each in turn, but we are going to try and concentrate on one aspect of this project, and that's the importance of judicial appointments. And of course, the United States has been so brilliant in showing us how important judicial appointment is, particularly if you have people there for lifetimes longer than many in this room. So can we now, without any ado, move straight to the first person? And it's Dr. Sophie Turenne, who's one of the co-reporters on this project. She's a real expert on the subject. She's been involved in it, I know personally, for at least 15 years, and her knowledge is profound. She teaches at Cambridge, but studies the judiciary across Europe and the world. And I'm going to ask Sophie to start and explain the project and the part we're talking about today.
Thank you very much, John, for your kind words. I'm fully aware that this is the last session before your lunch, so I'll go straight down to the point. I'm delighted to present, on behalf of our group of reporters, the draft standards, ELI-Mount Scopus Standards of Judicial Independence. There is no effective judicial protection or mutual trust without independent courts. And our project aims to promote some common standards of judicial independence across the European Union, on the basis that it is vital, and never more so than now, to insist on guarantees of judicial impartiality and independence for all judiciaries in the European Union. We developed the standards based on an existing set of standards, the Mount Scopus International Standards of Judicial Independence, which were consolidated in 2018. One main challenge for us is to strike the right balance between some universal, broadly desirable rules and some concrete, specific rules. And I will use today the example of judicial appointments, and by judicial appointments, I mean not only the appointment itself, but also the selection criteria and process, and the professional evaluation and promotion of judges. In the area of judicial appointments, then, many different methods apply. Many of them work quite satisfactorily, and there is often more than one method within one legal system. And these differences, we suggest, call for flexible standards between universal, broadly desirable rules and specific concrete rules. We tilt the balance towards the flexible and more universal rules. But we are also acutely aware that too much flexibility may weaken the effectiveness of our standards. This is why we intend, in the explanatory notes, to introduce some more specific guidance for interpretation in order to reinforce the practical impact of these standards. In the area of judicial appointment, we suggest that two significant issues emerge for consideration. First, we need some objective criteria for judicial appointments, and yet the notion of merit has been criticized for being elusive and giving way to self-serving judges or self-serving executive. Second, the degree of judicial self-regulation is a core issue in relation to judicial appointments. Within the EU, judicial self-regulation is usually associated with the institution of judicial councils. They have a wide range of powers, particularly in relation to judicial appointments. But we also know that in some countries, the existing political and legal culture has prevented judicial councils from guaranteeing judicial independence. So where do our standards and explanatory notes stand in relation to those issues? First, in relation to merit. Our standard number 2 reaffirms that decision by the competent body concerning judicial appointment must be based on merit, quote, defined by adequate, objective and published criteria. And our explanatory notes, in particular point 4, offer some details on the legal and judicial abilities and the personal qualities of a judge. But importantly, merit may be differently understood depending on the judicial post in question, as emphasized in our standard number 2. At one end of the spectrum of the judicial role, we see an emphasis on professional expertise and routine judicial business. At the other end, senior judges may need to grapple with issues of great political interest. And I think we have touched on some of those issues in the previous panels already. In the latter case, the judge carries great responsibility as an organ of government, and the judge may need to be more creative or wary than the lower court judges. The key to merit, therefore, is identifying the balance and importance of the merit criteria, depending on where on the spectrum of the judicial role the particular judicial post is placed. Second, where do we stand on the overall, on the issue of judicial self-regulation over judicial appointments? The issue is best understood, we suggest, by considering how far we need to avoid political influence in judicial appointments and how far we need an independent body representing the judges to make the appointments. First, in relation to the involvement of politicians in the appointment process, our standard number 1 affirms that political considerations cannot prevail over merit. It doesn't follow, however, that the appointment process must be insulated from politicians. The involvement of politicians may, in fact, give greater legitimacy to judicial appointments. Our standard number 1, therefore, occupies the middle ground with an emphasis on the need to, quote, safeguard against selection and appointments that would be perceived as biased or directed toward any other improper motive, undermining the independence and impartiality of the judiciary or the quality of justice. Second, on the extent of judicial control over the appointment process, our standard number 4 endorses the common use in European systems of some independent advisory or recommending body to select candidates for appointment. Under standard number 4, quote, the membership of the body with power to select for appointment or for promotion must be diverse, balanced, and composed in a manner that avoids bias, perception of bias, or any other improper motive. The composition of a selecting body must focus on its ability to identify the best candidate or the number of best candidates for the positions concerned based on merit and on the need to uphold the independence and impartiality of the judiciary and the quality of justice. The point here is that we introduce various safeguards to the membership of the selecting body in our explanatory notes, in particular in points 34 to 44. For example, in point 35, we currently maintain a majority of judicial representatives in the selecting body and a clear separation and independence from the legislative and executive powers as a guarantee of professionalism and independence. The same point 35 also endorses the participation of legal professionals and lay members in the selection process. This is because the inclusion of lay participants in the selection panel can be seen as a way to open a closed judicial system and therefore as a way to reinforce the integrity of the appointment process. In conclusion, judicial appointments is an example of an area where judges have been in desperate need of support within the EU. We have aimed to offer guidance on merit selection, and we have aimed to address the need to maintain some basic separation of powers, which is characteristic of the rule of law. And this is fairly representative of our wider work, as we suggest standards allowing flexibility in various areas, provided that there are necessary safeguards from undue interference. Thank you.
Thank you very much indeed, Seppi. And now we are having, who is not in person, but who will be appearing on the screen, Judge Raffaele Sabato. He is outstandingly qualified to speak on this subject. Not only has he been a judge of the Court of Cassation in Italy, he is now currently a judge at the European Court of Human Rights, but above all of that, he is a fellow and one of the people instrumental in getting ELI going, and in the period during the mid-decade of this century, or middle of the first decade of the century, had a tremendous role in advising the Council of Europe as chairman of the Consultative Council of European Judges and an expert on the issues relating to judicial independence. No one could be better qualified. Raffaele Sabato, Judge Raffaele Sabato.
Thank Lord John Thomas. Your friendship is probably prevailing over objectivity, but it is a pleasure for me to work with Eli at any time, and therefore to see friendly faces, and only regretting that this takes place by remote. I welcome this exercise on judicial independence and on the Mount Scopus European standards. I fully share what has been said before by Lord Thomas and Professor Turen, whom also I greet. I share also the view that the area of judicial appointments is the crucial one, for the reasons that I will try to quickly state in my short intervention. I would even dare saying that in addition to what at the present moment offers to us, all these emergencies, you know, the health emergency, the conflict emergency, the possible following energy emergency, and the climate emergency, there are emergencies in Europe linked to the judiciary. This started here in Strasbourg in 2020, but it has started even before, as we all know, at the Court of Luxembourg with the Polish cases. I will not have the time to dwell with this kind of general references. I will go straight to the point and just recall what my benchmarks are. So my objective is to sort of make a few remarks comparing the content of the Mount Scopus, that now will become ELI-Mount Scopus European standards, with the standards that we can derive from Council of Europe documents and European Court of Human Rights case law, starting from the latter. So in 2020, we had the Grand Chamber judgment, Gudmundur Andri Austravsson versus Iceland. And from then on, starting in 2021, we have had a number of so-called Polish cases concerning judicial reforms in Poland, the main one of which is Grzenda versus Poland by the Grand Chamber, but this does not directly address the issue of appointments. There are a number of other ones that relate to appointments of judges in the Constitutional Court of Poland, appointment of judges in regular courts of Poland, and also in two newly established chambers of the Supreme Court in Poland. I will not give references. Coming to the Council of Europe standards, I've noticed that correctly the present draft refers to a recommendation of the Committee of Ministers of 1998. This has been replaced in 2010 by another recommendation. And then, of course, you have a number of opinions of the Consultative Council of European Judges, a body that our Vice President, Lord Thomas, knows probably now more than I do, but these are quite important as references in my point of view. After framing more or less the benchmarks, my remarks, they will be very short. I counted 5 of them, and I will use 1 or 2 sentences for each. The first remark, I welcome links that the draft establishes between independence and especially appointments, and other concepts such as accountability, efficiency, accessibility, public confidence. let's only reflect on what is the link between these values. These are core values to be certainly pursued when we draft a common new version of these standards, but they have probably less to say talking about appointments, because appointments is certainly a moment in judicial career which has to do with merits, with independence and qualification of the judge. So the same can be said concerning justice and technology and other areas that are covered by the principles. My second remark: the present version of the draft, in point 2.4, accepts that judges may be appointed by the executive power of the state, provided, of course, that there are a number of procedures preventing the executive from making judicial appointments as a tool of partisan politics. I must express some reservations on this, although we have in Europe a few countries in which the appointments in the judiciary is at least formally made by a minister. The present standards that you might easily check in Europe provide that the safeguards should be a little bit stricter, in the sense that usually interventions of other powers of the state should be limited. The Venice Commission tells us that they should be only in the hands of a head of state, or if there is another power, this should only be a formal exercise of power, because they should be limited in receiving objective assessments from an independent body selecting the judges. This was repeated in the Gudmundur Andri Astrason judgment by the Grand Chamber that I mentioned before. My third remark is there are a number of ancillary topics that are not directly related to appointments, but that they are closely similar to appointments. And so the first area in which we should be careful is the area of assignment of cases to individual judges, or removal of cases from one judge to another judge. There is no established practice in this area, and some latitude should be left. This is the area in which the principles see very clearly, I would say. So I fully share their approach. Some latitude should be left to chief judges in order to increase efficiency. I mentioned the link between efficiency, etc. So if a docket of a judge is too heavy, you can move cases, or for some other objective reasons. Please let us consider if this should not be done on the basis of predetermined criteria, that the judge should be heard and that some review should take place. Otherwise, it would be easy to appoint a judge and give him only traffic violations. My fourth remark, an area also closely linked to judicial appointments, is certainly the area of transfer and removal of judges. In the area of removal, here you have a very clear provision in the Committee of Ministers recommendation of 2010 that I mentioned before, and that I cannot explain in full here. But for sure, in order to sort of making compatible the present text With European standards, I would say that here the role of an independent body, such as a High Council for the Judiciary or an equivalent body, should be included in the draft. Of course, removal should also include a possibility of a judicial review. This is more or less the content of the recommendation that I would recommend considering when dealing with principle number 3.6. My fifth and final remark, which has nothing to do with appointment as such, but it concerns the possibility that because of behaviors of the judges, a removal or a disciplinary measure could be taken. So sort of what comes after an appointment and can, of course, impact on tenure of judges. I'm referring to the freedom of expression of judges, to the role of authorizations by the judicial hierarchy for the judge to speak, to lecture, to possibly express in public, both personally and in association, his or her own point of view. This topic was recently addressed in a Polish case, which is called Jurek versus Poland, which is not yet final. I would advise the ELI group to reflect on this. I would be available to provide more information. And I would only remember that the Consultative Council of European Judges in November 2022 will issue an opinion exactly in this area. I would stop here, but I would really once more express my gratitude for this invitation and my regret that we are separated by a computer screen. Thank you.
Thank you very much indeed, Judge Sabato. And now we go to Karen Hammer, who is going to speak to us from the perspective of someone with real practical experience in the field. She is a legal advisor to the Organization for Security and Cooperation in Europe, OSCE, and for the democratic institutions and human rights part of that. And she has worked for OSCE for some time and has experience in judicial systems and in accountability. We look forward very much to your presentation, and thank you very much for coming.
Thank you very much. On behalf of the Organization for Security and Cooperation in Europe's Office for Democratic Institutions and Human Rights, I would like to thank you for the invitation to join you here today at the ELI Annual Conference 2022 and to share some feedback on the ELI project on the ELI-Mount Scopus Standards of Judicial Independence. As you might or might not know, at the beginning of 2022, OSCE ODIHR became a formal observer to the ELI project on the ELI-Mount Scopus Standards of Judicial Independence. In practice, what this means is that a representative of ODIHR attends key meetings of the ELI project team, and drafts of the project team's work are shared with ODIHR for feedback. In turn, ODIHR has benefited significantly from dialogue with and feedback from the ELI project team reporters as part of our own ongoing process of review of the 2010 Kyiv recommendations. Based in Warsaw, Poland, ODIHR is an independent institution of the OSCE with a mandate to support OSCE participating states by promoting democratic elections, respect for human rights, tolerance and non-discrimination, and the rule of law. ODIHR carries out this work based on political commitments that the 57 OSCE participating states have made to one another. The concept of rule of law is a cornerstone of the OSCE's human dimension of security, and OSCE participating states have recognized the independence of judges and the impartial operation of the judicial service as one of the elements of justice, which is essential to the full expression of the inherent dignity and of the equal and inalienable rights of human beings. They have further committed to ensuring that the independence of the judiciary is guaranteed in law and respected in practice. In this regard, OSCE and ODIHR in particular is responsible for providing support to OSCE participating states in upholding their commitments related to judicial independence through a range of technical assistance and capacity building activities. These include the development and updating of tools and methodologies, providing expertise, and facilitating dialogue. As I previously mentioned, one of the tools which ODIHR has developed to support OSCE participating states are the 2010 Kiev recommendations on judicial independence in Eastern Europe, South Caucasus, and Central Asia. The Kiev recommendations were developed by ODIHR together with the Max Planck Institute for Comparative Public Law and International Law, and they were developed to disseminate good practices in judicial administration in the regions identified. Since their publication in 2010, the Kiev recommendations have served to articulate compliance with international standards and good practices for judicial system reforms. We've seen that these have been extensively utilized by national authorities, but also by civil society, OSCE field offices, and international organizations. In 2019, we started a process of review of the Kiev recommendations to correspond to what we saw as current challenges in the field of judicial independence. Our goal has been and is to update the document on the basis of detailed assessments and through extensive consultations with justice sector stakeholders and leading experts from OSCE participating states. In the earlier phases of the project, and relevant to what we have already heard the speakers today mention, we identified a number of issues as particularly relevant and problematic in the context of the current time, but where we found that more in-depth analysis of challenges and good practices in participating states was required. These included freedom of expression of judges, disciplinary accountability of judges, the issue of transfer of judges in light of the irremovability principle, and the accountability of judicial councils and other self-governing bodies. ODIHR commissioned a series of thematic assessments to be drafted by experts on these 4 topics, and from 2020 through 2022, ODIHR has organized a series of workshops across Western, Central, and Eastern Europe, Southeastern Europe, South Caucasus, and Central Asia in order to consult with a wider range of experts to receive input for the technical drafting of the revisions and amendments to the Kiev recommendations. We've also held both online and in-person consultation meetings with a wide range of experts. ODIHR would like to thank the ELI project team reporters, including Sophie Turen and Leah Wortham in particular, for being among this group of experts. The feedback that we've received on the thematic assessments during these workshops and consultation meetings has informed the draft text of the updated recommendations. We see both the Mount Scopus Standards of Judicial Independence and the 2010 Kiev recommendations as 2 of the various useful reference documents which have been elaborated over time to help ensure the independence of the judiciary. And we see the expansion on core concepts related to judicial independence, which both of our updated project documents will provide as particularly useful given the heterogeneity of political and legal systems and differences in legal culture across the states. Therefore, we look forward to continued participation in the process of development of the ELI-Mount Scopus standards and to continued fruitful cooperation with ELI in this area. Thank you very much for your time, and I look forward to our further discussions today.
Thank you very much indeed, Karen, for your very careful. And our last speaker in the panel before we turn to questions and to the discussion is Pablo Alvarez Martinez. He is a graduate of the University in Granada and he did his master's degree in Madrid, but unfortunately not at this university. He is coming today speaking with the experience of having worked and still working for DG Justice and in this particular area. So we look forward very much again to a view essentially from the coalface, as we've just had, as to the way these standards are to be applied in practice and how we can get them to be better and uniform.
No, thanks very much. First of all, thanks to ELI for the invitation to the European Commission to this event. We are really glad to be here. And I will focus my intervention mostly on what the European Commission we are doing in the field of judicial independence and broader on the rule of law area. And then I will focus at the end on how can we have synergies and how the specific project can be of an actual use in the work that we are doing. So the European Commission, in its role as the guardian of the treaties, is in charge of ensuring that the common values of the European Union, as enshrined in Article 2 of the treaty, they are protected. And one of these common values is the rule of law. In our field, we have a broad definition of the rule of law, but one of the pillars of the rule of law, as all of you know, is the justice systems and the judicial independence. And in this sense, the Commission has, in recent years, developed a number of tools and instruments to address and to try to contribute to address challenges in the field of rule of law. Those tools and instruments, they are focused on two different blocks. One is the promotion and prevention on issues, and other is the response when these issues cannot be prevented. Going to the first block on promotion and prevention, the main tool that we are using and developing from the European Commission side is the Rule of Law report. This is a report that we have published since 2020 in an annual basis, and we have 27 chapters, one for each member state, where we assess the different areas of the rule of law with a special focus on judicial independence. And we have a chapter for each member state. But I will come back later on this, because this is one of the areas that we see that we can have some synergies. But there are other promotion and prevention tools that we are using to ensure judicial independence. One is the EU Justice Scoreboard that it has been published since 2012. And this is another report where we publish quantitative and qualitative data and comparative data of all member states in the areas of independence, quality, and efficiency of national justice systems. Of course, we have other tools like financial programs to support civil society, and even judicial networks and specific reforms on member states regarding the effectiveness, quality, and independence of justice systems. But as I was saying, we can try to prevent as much as possible issues regarding judicial independence, but this is not always possible. So this is when the EU, we need to react, and we have response tools for that. The most known tool that we have is the infringement procedure, where the Commission brings to a case before the Court of Justice when we think that there is no violations on EU law. And in the field of judicial independence, many of you probably are aware that we have brought in the recent years a number of cases against one specific member state, that it was Poland. The most recent one, it was a case on the appointment of judges of the Constitutional Court. We have more response tools. One is probably the nuclear power, as we call it, is the Article 7 of the Treaty of the European Union. That this mechanism is a mechanism of the Council that can suspend the voting rights of a member state in case of violations of the rule of law. Currently, there are two Article 7 procedures being discussed in the Council, one for Hungary and one for Poland. They are still ongoing, and the Commission is supporting the Council in this respect. And finally, regarding the different tools that we have, we recently have a new one. It's the regulation on, as we call it, on the general regime of conditionality for the protection of the union budget. We commonly call it the conditionality mechanism. And according to this new regulation, the Commission can propose measures to the Council to suspend the disbursement of funding to member states in the case that we have found that there are breaches to the rule of law, and if these breaches have an impact on the sound financial management of the union budget. Currently, we have the Commission has sent a notification to Hungary using this mechanism, and we are now in discussions and in an early stage to see what remedy measures Hungary has provided and if this will be acceptable. But coming, as I mentioned before, to one specific use that we can see for this project is one area that we can see it can be useful is, as I mentioned, the rule of law report. As I was mentioning, the rule of law report, we have different areas where we assess the different situation on the rule of law regarding justice systems, anti-corruption, media freedom and pluralism, and in general other institutional issues related to checks and balances. And for this report, it's a really comprehensive exercise. So the methodology that we use is a range of visits and meetings with more than 400 stakeholders and authorities across the EU. But also we use public consultations and other meetings at horizontal level. And with these meetings, we identify potential issues that we think that we can prevent, and we hope that they are not developing and they worsen worse. And we compare this situation and these issues against a number of standards. These standards, they are of different nature. Of course, the most common ones are EU law, that of course the treaties, but sometimes also secondary law, of course the Charter of Fundamental Rights, and other areas. But we also rely on a number of the case law of the European Court of Justice, as well as the case law of the European Court of Human Rights. And finally, we also rely on as Judge Sabato was mentioning, on the standards of the Council of Europe and opinions of the Venice Commission. In particular, regarding the appointment of judges, we rely a lot on the recommendation of 2010 of the Council of Europe on judicial independence. But these standards that we rely on, they are not always granular enough. And for that, we need to have more concrete benchmarks. And this is where we think that projects like the pilot project of ELI, we think it can be really useful and really great, really to the point. For example, we think that it's really interesting the definition of merit and all the development of there. We think it's quite relevant and we can really use it. But of course, for the Commission to include those standards in our assessment, they need to be recognized and to be clearly and well known across the EU. So this is why we think these initiatives are really important, and we really encourage you to continue in this path. And we're really also happy to continue discussions, also maybe in the context of the preparation of next year's report. And I will leave it.
Thank you very much indeed. And I want to thank all the speakers for having been so focused and complied absolutely with their time instructions. Now we've got, therefore, some time for discussion and questions, and I'm going to take you in a group. And those who want to speak, if you raise your hands, and we'll pick up 3 or 4. I've got one here. If you make your remark, then I'll come second, third, 4, and then we'll get them all answered in turn. Yes, Professor Schertreed.
First of all, I would like to thank the speakers and the excellent chairman, including the online participant, Judge Sabato. I would like to also thank my colleagues in the reporters of this project, Lea Wortham, it's right next to my right, and Frederick Zoll, I don't know because I haven't seen him this morning, but
he's there.
Here he is. And so all together with Sophie, we've been working quite intensively to try to develop these European standards that are based on Mount Scopus, but revised and adapted to the new and challenging situations. I would like to make just very brief comments that derive from the issue of judicial independence, judicial appointments, because the issues are very broad, but I would like to make just very brief. One point is, what is the importance of institutional independence of the judiciary as a branch of government and as a corporate body in the system of government? And once we decide on this role, then we can make certain conclusions regarding some of the points that were made. For example, to what extent is it legitimate that the legislature or the executive would take part in appointments. The position we took in the Mount Scopus standards and also in the new revised proposal that Sophie just presented is that it is legitimate. The question is how we make sure that it is not abused. The issue of abuse will exist in any system that we will adopt, and so the main challenge is to make sure that this type of abuse will not happen. So that's one point I want to make. And the other point I would like to make is the issue of the balancing between what we think as desired general standards or universal standards or European standards and the local jurisdiction's circumstances. So let's say, take an example, on the one hand, the emerging democracies like Poland, Hungary, etc., or other countries that have high judicial councils. High judicial councils could be very nice and could, in fact, be very good system of defending the judges, but sometimes if they are controlled or their composition is controlled by the executive, then they turn to be problematic because this opens this old institution, very old and accepted institution in the European tradition, it is already a source of a problem. So the question is, to what extent a certain practice that has existed in many countries, when it is abused in a certain situation like changing the composition, that the European Court of Human Rights or the Luxembourg Court will have to decide that in spite of the fact that certain institution is ancient in the history and the legal history and the legal culture of Europe, nevertheless should be ruled in a certain circumstance as illegitimate. So I think that is one of the very, very difficult issues that we have to be mindful, to state the general principle, but on the other hand, be very careful not to disregard the local circumstances in each of the jurisdictions.
Thank you for those two questions. Let us pick up two more. Yes, Professor. Yeah, and then we'll go there and there.
So thank you, Mr. Chair. Lorena Bachmeier from Complutense University, Madrid, and 15 years being consultant for Council of Europe on judicial independence and transitional democracies. I'm very happy to see also Caroline Hammer, as I have been very much working also with OSCE. I have only two questions because we could go on discussing on the role of councils and so forth. I've been also within the rule of law mechanism. Thank you for your work because the Justice Scoreboard really helps, and the cooperation with CEPEJ really means something very important for us in Europe. My question was first to something that our judge mentioned on the case allocation. And this should be very important. However, obviously, when we talk about allocation of cases, it should be, as the recommendation of 2010, number 12 of the Council of Europe says, point 24, is that it should be in an objective and pre-established way. However, it was seen already in the report done in 2016 that it was not a very salient, problematic issue in the 49 member states. So no more action seems to be needed, was the conclusion set up there. So do you still see problems within the systems of allocation of cases, taking into account that almost all countries have pre-established rules and many of them automated case allocations? And my next question is to Sophia. Sophia, you are kind of trying to solve the insolvable, which is defining the system of selection of judges in merit-based. And believe me, if you find a solution, you will be a Nobel Prize, because I mean these criteria also set up in the recommendation in 2010. I mean objective and merit-based. And every time we have been on the in the missions and on the spots, be it Ukraine, be it Armenia, be it Azerbaijan, be it any of the countries in Central Asia, trying to talk to the qualifications and selection commissions what should be done. They can trick you all ways. So please, if you can tell me how to define merit, except from doing some kind of examines, competitions, and so forth, by an independent body, which in these countries is quite difficult, please provide it, because it's absolutely always the sore point in these countries. And finally, I'm very happy to see that the OSCE is continuing to work in the same areas identified also in the Sofia Action Plan by Council of Europe, which is obviously disciplinary accountability, internal independence, and the role of councils, and freedom of expression. Thank you very much, and please provide me with some insight what is the
We'll do our
closer
best.
approach.
We'll do our
Thanks.
best. Yes, here, and if you can just briefly introduce yourself, that would be brilliant.
Thank you very much. I'm Rita Shimon from Czech Republic, but working in Czech Republic. I'm happy I'm there, but I'm originally from Hungary, so I really know what you are facing for. I would like to say 2 remarks and 1 question. This over-politicization of the judicial system is a slowly and steady development. So therefore, it's very hard to find the right approach. But I think it is too late, or it is very, very hard to make new rules if the chief judge or this self-government body of the judicial system is already over-politicized. So my question is what to do in the case when already political loyal judges are sitting in all these committees. How to safeguard this? And the second, the only way I see the German judicial system has this rotation system. So the judges are removed, when I'm not fault, every 5 years in another senate. It is maybe not this the key not to make 2 monopole systems. Thank you.
Thank you very much. Yes.
Hello, I'll try to be brief. My name is Anna Knežević-Bojović. I come from the Institute of Comparative Law in Serbia. So obviously, as an accession country, we're looking at the EU and the developments in the EU when it comes to justice sector reforms. And when you talked about conditionality, well, of course, for the past, I don't know how many years, we've been subjected to external conditionality from the EU concerning rule of law and, of course, judicial independence. I would also like to make a couple of remarks and ask a question. One of the things that I would highly commend is the position on having the members of the Judicial Council being come predominantly from the judicial profession. Because what we find is that the Venice Commission sometimes, in its individual opinions, puts the threshold of this balance between the judicial members and the lay members, or the members from the executive, a bit lower than the Consultative Council of the European Judges. Coming to the lay members, the countries which are currently undergoing substantial substantive judicial reforms, such as Serbia, but also Montenegro, are facing a challenge in defining the qualifications and the procedures for the appointment of the lay members of the Judicial Council. So my question to you would be, how would this question be addressed? So who are the lay members who are best qualified to participate in this complex decision-making, which is not only to do with judicial appointments, but also disciplinary liability, judicial ethics, and the judicial budget, which is an increasing power of the judicial councils. Going back to what Professor Sabato said, I'd just like to make a comment which has to do with the approach in terms of adopting flexible rules. Now, flexible and open rules, of course, are something that is a standard setting when you're developing standards. But for EU accession countries in particular, it's very useful to have specific additional guidance on the issue, because sometimes the countries faced with EU, Venice Commission or Greco recommendations are keen to tick the box, but are not keen or don't understand what the substance is. So, for instance, Serbia had a Greco recommendation saying you need to have a body that will provide confidential counseling on judicial ethics. So, what kind of body is that? There is no European standard on the issue, so the country is keen to tick that box, but how should it be done? And hopefully I would like some additional inputs on how the standards of judicial independence and to what extent will they elaborate on judicial ethics, because I think that judicial ethics and integrity are an imperative part of achieving judicial independence. So, thank you.
Well, there are a series of questions, and let's stick at those four for the moment. I was going to ask Sophie to take the first one and deal with the question, really, of defining judicial merit or judicial appointment, the criteria, and then we'll pick up the broader questions in a moment. But if you could start with that, Sophie.
Thank you very much. So you're absolutely right, and I started by saying that merit is a notion that is fairly elusive, and it has been criticized for that. I think there were 2 points in what you said. There's a point about merit itself. How do you define it? And then there's a point about when you go to a particular country and you try to understand what it is that they mean by merit, that they will have a different interpretation, but they will not necessarily apply what you think they are saying they will apply. So in a sense, it's a question of monitoring and engaging with that particular country. But to come back to the first question, which is how do we define merit, we thought that already, compared with a number of instruments, we are going a little bit into more details, into greater details in spelling out qualities. And you're absolutely right that they still remain at the relative general level. But we think that this is where we need to stop, because we need to engage with the particular circumstances of the countries. So I would say that already we're trying to be more concrete, but we acknowledge that at some point it's a dialogue with a particular institution in seeing how they can advance it. But I would say that this is where perhaps our standards have a signaling function. So we acknowledge the limits, but there is a signaling function, and what may seem already quite basic for some will still be quite demanding for others. Thank you.
Thank you very much indeed, particularly in the light of the comments about the need for granularity. It's very important. Now, what I was going to next do is that one of the key themes of the questions has been if there are to be appointments and the executive is to be given a discretion, what's the role of the councils for the judiciary and how do they fit into this? I think that was a sort of key theme. Do they provide institutional safeguards? How should it be balanced? And I was going to ask Caroline, if you would like to help on that in the light of your experience.
Yeah, thank you very much. As I mentioned, one of the topics that we've been looking at in our process, and I know that the ELI project has looked at as well, is with regard to the accountability of judicial councils. And I think this speaks more broadly to the constant and ongoing need to balance independence and accountability within any given system. So finding and maintaining this balance between judicial independence and accountability, I think we've seen as an ongoing challenge, at least for all OSCE participating states. And this is regardless of their history or the type of justice system which is in place there. And more broadly speaking, in the absence of this type of balance, a judiciary may be subject to complaints of corporatism, elitism, or lack of accountability, which undermine its credibility and its position within the broader system of checks and balances. This, we've seen, is one of the challenges with judicial councils as bodies in certain participating states. And this has been pointed to by some of the speakers. On the other hand, measures which are too intrusive will risk exposing the judiciary, of course, to undue influence by external actors. And this is the purpose for which judicial councils were created, but is not always how they function in practice. Maybe just to speak to the question that was also raised, if I may, about how to cope with the heterogeneity of systems when formulating these recommendations more broadly, I would just say that we can see that judicial independence only thrives, whether there's a judicial council or not a judicial council, whether there is one self-governing body or a proliferation of self-governing bodies. It only thrives within a broader ecosystem of well-functioning checks and balances, and no specific individual measures or bodies or not bodies will be effective in and of themselves in the absence of a culture of the rule of law and a culture of powers which are more broadly separated. The absence or presence of particular checks and balances or particular safeguards does not guarantee that those will function well in practice. And this is across the OSCE region what we have seen, and the challenge that we come up against with trying to formulate recommendations for how to operationalize those. Any system can ultimately become vulnerable to being undermined or to being compromised. So I think it's very important to look at the whole picture here and not to get too lost in very specific details, but rather how all of those details are functioning more comprehensively.
Thank you very much indeed. Then before going to Rafael Sabato on more general points, I wanted to ask you, what sort of granularity do you need to make the states more accountable in relation to the two principal topics, the involvement of the executive, the role of the councils, and the way in which you define merit? What do you need to help effectively enforce independence?
Yeah, actually, that's one of the main issues that we face when working on the rule of law report and so on. So the thing is, at the end, it's not always easy when you have standards to compare two institutions from different countries separately. You have to make an assessment of the whole justice system, the checks and balances, institutions, and so on. And maybe also coming to the issue of institutions or traditions that they have been there for ages. From the European Commission and also the Court of Justice of the European Union, sometimes the main issue is the non-regression principle, because sometimes you have institutions that they have been working for really long time there, but there are other systems of checks and balances that they compensate it. But in some specific cases, for what we have infringements, is that there was institutions protecting judicial independence that they have been dismantled or they are trying to be dismantled more recently. And this is where the issue comes. Coming to the granularity, that's what actually we try to do with our country chapters of the rule of law report, to try to see what are the specific issues. The issue of the Judicial Council is something that we speak in many, many countries, like in Poland, Spain, Portugal. So it's not something that is independent of one specific member state. We have this in many, and there are also to respect that there are countries where member states that they don't have judicial councils and they have other issues of appointment. So at the end, it's important to make an assessment of the whole justice system as a whole and try to understand the different links and interconnections.
Thank you very much. Now, before going to Judge Sabata, we've had one comment that's come in, which is, I think I'd quite like to read you. It's from Judge Stadelmann, who's the judge of the Supreme Court of Switzerland and a director of the Swiss Institute for the Justiciary. And he says the appointment of judges has two main aspects. The most suitable person should be selected, and the selection should not compromise the independence of the judiciary. The international standards essentially discuss which organ should be responsible, the legislature, the executive, or a specific body. In Switzerland, an alternative model was submitted to a popular vote last year in connection with the election of judges to the Swiss Supreme Court. It was rejected because it was rejected in the referendum, probably because... Sorry, I'm now showing my lack of computer skills. In popular vote to the Swiss Supreme Court, it was rejected in the referendum, probably because the considerations were too progressive. He then asks the question, what about this model? A commission independent of the legislature and the executive, considering 10 to 15 experts from the different fields important for the function of a court, e.g. lawyers, political scientists, social scientists, with a one-time term of office of 10 years. That's sort of independent commission. And that was one part of the model. And the second part is the task of this commission is to examine candidates for the office for suitability. In the event of a vacancy, the new judge is selected by lot from the candidates qualified as suitable. The procedure is intended to ensure, therefore, the necessary formulation of independence, a proper means of selecting judges. And I was going to ask Judge Raffaele Sabato for his general comments, and can you include in it the problem of case allocation? And I'll come back on any other observations you want to make. Then I want to go right across the panel again to see if there's anything they want to pick up. Raffaele. We've lost his sound.
Okay, now the connection should be established. Thank you, John, for your comments and question. I would start from President Stadelmann's idea of mixing, so to say, a technical selection with some randomized then appointment in order to take away from humans, so to say, whatever problems humans may have, including influencing appointments, etc. Let me only answer by sort of referring to one of those cases I was mentioning in my previous intervention. In the case Gudmundur Andri Astradsson versus Iceland, the Grand Chamber was dealing with a similar situation of a technical commission who had made a ranking of candidates, and then the minister skipped some candidates from the ranking and chose one or two more candidates low in the ranking. This was voted unblocked by the parliament, and the European Court of Human Rights found a violation of Article 6 concerning a vitiated judicial appointment. So that is there was no reasoning, there was no other thing. So, this apparently could be a sort of support for the idea of President Stadelmann. I would, however, have reservations on resorting to a sort of lottery. I think that most of the European standards, as Professor Turenne was mentioning at the very beginning, refer to merits. And I think that having a wide range of candidates and then a lottery probably implies a sort of giving up to the criterion of merits, because it's only apparent that you say, you know, they are all equally worth of being appointed, because, you know, you have civil judges, you have criminal judges, you have administrative judges. Even in large countries such as my own, you know, you would have even difficulties recruiting enough judges. This is the case in Italy these days. We do not cover the number of places that we have available. So that's the reality for some countries. I would stop at this point. Thank you, Mr. President.
Yeah. Sorry, so, Raffaele, did you want to say something about case allocation? Because you were asked specifically about that.
Sorry, about case allocation, yes. It was one of the points that I covered before, and I welcome the question that came. I think that case allocation is a critical point. We have many cases in which we see in some countries that judges are taking a standing because their cases are transferred from one judge to another. So basically, I do not exclude, as I was mentioning, we do not have case law at the moment, that the power that, however, should be recognized to chief judges to organize the service should be framed by way of predetermined rules, and judges should have their say. That is more or less my position, based on CCGA standards, and in part also on recommendation of 2010. Thanks.
And so I'm going to ask you one other point to deal with, and that really was the question: how do you deal with making certain councils for the judiciary have a sufficient degree of independence to protect institutionally the judiciary and not be subject to rigged appointments either of judges who have a political persuasion or by members of society who have a political persuasion? How do you ensure that the councils of the judiciary can be independent?
You are now addressing a very painful topic because in my country we are in the middle of a crisis which exactly concerns that some kind of over politicization of counsel for the judiciary because of the increased powers of appointing judges. We had before a seniority rule which was rather clear, and then the merits rule prevailed over seniority all the way, and the crisis came. I would say that there is no way. There is a way, of course, to decrease the role of judges in the Council for the Judiciary. I think that one of the intervenants pointed out to that. I would not believe too much in that. I would say that having members of the outside society is good to avoid chronism and other phenomena, but still judicial councils should be somehow judicial. So the role of ethics that another intervener mentioned, it's not the role of ethics concerning the appointees, but there is a role of ethics for the appointers. That is the relevant, the crucial element. We should find a way to sort of bind behaviors of the appointers to specific profiles and rules. And I think that's the clearest and more transparent way to avoid dangers. Thank you.
I wanted to ask the other panelists if they wanted to add anything in the light of the remarks that have been made. And if we have time, then I'll ask if there are any more other questions.
Just to say that I endorse Judge Sabato's words on judicial councils, that I think also in answer to one of the questions that was raised, that it is a very difficult issue, the membership of judicial councils, but also this emphasis, the recent emphasis on lay members and members of civil society. And I find this is a thorny issue, and I do welcome your point about clarifying the qualification of what is it that we mean when we are inviting lay members to join in judicial councils. Are they representative of society? Do they have a particular expertise? So thank you for that.
Anything you wanted to add, Caroline?
I would just add that within our process as well, this question of standards and procedures for appointment of lay members of judicial councils is one which many participating states have struggled with and which we've heard very different solutions for. So I think for us, this has also been one of the very thorny issues. I would also just like to introduce one element that we haven't talked about, if I may, but which I think is also crucial when we're talking about separation of powers and trying to understand how to prevent the undermining of this separation of powers. And this is with regard to public awareness and understanding of the role that an independent judiciary plays in guaranteeing and safeguarding human rights and fundamental freedoms. And when the judiciary is seen as self-referential, self-protective, or this kind of a closed club, its independence as a branch of power is much more susceptible to being undermined. And as we have tried to go through our own process of updating the key recommendations, we have tried to reflect this. And I think this is an important part of the conversation that we constantly need to bear in mind in the background as well. Thank you.
Thank you very much for that important point. I wanted to ask, are there any other questions that people, I think we've got time for one or two more questions if anyone's got a burning question to ask. No. Good. Well, having started on absolutely to time, I just wanted to say thank you to all the panelists, particularly to Judge Sabato, Raffaele Sabato, for having appeared online, not having the pleasure of coming, and our panelists who really brought to bear some of their own experience of what is needed. I fear this body, in drafting these standards, has a formidable task, and a task that will grow more difficult, because as the first session showed, people want judges to do things that politicians are failing to do. If judges start to do things that politicians are failing to do, you can be absolutely certain the politicians will want to control who will be the judges. And therefore, the key issue raised by Professor Chetrit, I think at the outset, is the question, how can you allow, what safeguards do you put in place to stop the executive, if they are to appoint, other than purely formally, abusing that power? And how do you do this? How do you make councils for the judiciary work? Or should we give more consideration to what the Swiss suggest? I don't know, but this is a topic that I believe will become more and more important if you are to ask judges to save the planet. So thank you.